Today's brief lecture focuses on a pivotal distinction within the law of defenses, the distinction between justifications and excuses. I'm going to talk first about the distinction itself, and then get into why it matters. We'll start with justifications. To say that one is justified in committing a criminal offense, and should therefore be acquitted, is to say, in effect, that one's conduct is, all things considered, not wrongful. So far as the law is concerned, the commission of a criminal offense is always a prima facie wrong. What a justificatory defense does, however, is set out the conditions under which conduct that is ordinarily wrongful becomes permissible. The classic example is self-defense. Murder, of course, is a crime. The intentional infliction of death upon another is absolutely a prima facie wrong. But Parliament has set out conditions in Section 34 of the Criminal Code under which I am permitted to use lethal force against another. If those conditions are satisfied, then I do nothing wrong in using lethal force, notwithstanding the general prohibition. Excuses, on the other hand, operate on a very different basis. To say that one is excused is not to deny that one engaged in wrongdoing. It is to say simply that one should not be blamed and punished for having engaged in wrongdoing. Take, for example, the defense of necessity. As we will see, there are circumstances under which one can claim that one had no real choice but to break the law. Now, the law, in no uncertain terms, does not give anyone the right to decide when a criminal offense provision should be followed and when it shouldn't. So far as the law is concerned, your responsibility is always to obey the law. But the law does recognize that under some circumstances, people may experience such extraordinary moral pressure to break the law that they cannot be expected to withstand that pressure. And so we don't punish such people, treating their decision to break the law as broadly analogous to involuntary behavior, as morally involuntary. Their conduct is treated as wrongful, but excused. As we'll see, this distinction between justification and excuse is somewhat unstable, in part because it is not always obvious which defense is which, but also because we have concerns that ordinary people will treat excusatory defenses as justifications, that they will regard themselves as permitted to break the law and therefore be too quick to do so. But the distinction between justification and excuse is nonetheless of pivotal importance. Why is it important? Well, in part, it matters because it affects who has authority to make defenses in the first place. Recall my early video on sources. Note that whereas Section 9 of the Code precludes the courts from creating new offenses at common law, Section 8 sub 3 recognizes the power of the courts to create or alter common law defenses. Now that would seem to suggest that the courts have authority to create or expand both justifications and excuses. But that is not how Section 8 sub 3 has been construed in practice. And that has everything to do with the separation of powers considerations that I emphasized in the sources lecture. Remember why the Supreme Court in Frey versus Federer and Parliament with Section 9 of the Code decided to abolish common law crimes in the first place. The criminalization of a course of action has profound social policy implications. It can transform social life in the community. Its institutions and relationships may be radically affected by the recognition of a new crime. And it may take conduct that is widely regarded as acceptable, even praiseworthy, and in a stroke, turn it into conduct that is henceforth to be treated as worthy of condemnation and punishment. With that in mind, the courts and Parliament have taken the view that if anyone is to create criminal offenses, it is to be our elected representatives. But now let's return to the distinction between justification and excuse. A justificatory defense operates on the basis, as we've seen, that conduct that is prima facie wrongful may be, all things considered, permissible. It proceeds on the basis that even though Parliament has made it an offense to engage in a course of action, the defendant was nonetheless permitted, under the particular circumstances confronting him or her, to engage in that course of action. Now, that's not a problem if it is Parliament that creates the justification. It created the offense, and it is entitled to qualify that offense by setting out the conditions under which one is permitted to do what is ordinarily forbidden. But this is a problem if the courts create the justification, because the courts are then purporting to take conduct that your elected representatives have decided is forbidden and declare it permissible, not wrongful. The social policy decision made by Parliament, ostensibly in your best interests, in the interests of the common good, has been undone to some extent. And it is difficult to see how that could be defensible on separation of powers grounds. By contrast, excusatory defenses do not make otherwise wrongful conduct permissible. They operate notwithstanding the fact that the defendant acted wrongfully in committing the offense, whatever it was. It follows that recognizing excusatory defenses does not have, quite simply, the same social policy implications as recognizing justificatory defenses. Because even if a defendant is acquitted on the basis of an excuse, the conduct itself remains wrongful and unambiguously prohibited. And so what we've found in the case law is a more or less consistent attitude that whereas courts may recognize and expand excusatory defenses at common law, they may not do so with regard to justificatory defenses. So the distinction between justifications and excuses is important to making sense of Section 8 sub 3 of the Code. This is because, as I've said, justifications confer upon the public at large permissions to engage in otherwise wrongful conduct, whereas excuses don't. That doesn't mean, of course, that all bets are off with respect to excuses. Courts do worry that recognition of excuses may inadvertently send the message that it is okay to commit criminal offenses. The public, of course, isn't necessarily attuned to the different bases for justifications and excuses. And so there can be what has been sometimes described as quasi-justificatory drift. Courts worry that by treating conduct as excused, they will inadvertently encourage the public not to follow the guidance of Parliament, that they will be too quick to proceed on the basis that they had no choice but to break the law. And so the courts have not adopted purely subjective tests for necessity or duress. They have imposed stringent conditions on when these defenses can be used. And they've sometimes struggled over whether the commission of certain offenses can be excused at all. Finally, and for the sake of completeness, I would point out that there is a third category of defense: institutional defenses. It's important to put some scare quotes around defenses here, because strictly speaking, these don't negate either the wrongfulness of the conduct or the culpability of the defendant. Rather, they operate effectively on the basis that the Crown lacks the moral authority to prosecute the defendant. Now, the par excellence examples of institutional defenses are defenses like entrapment, officially induced error, abuse of process. I'm going to speak more about those defenses later on. But for now, it is enough simply to observe that these neither justify nor excuse the defendant's conduct in any straightforward sense, but rather insist that the Crown is either implicated in the wrong or has abused the criminal justice system in some way. In this lecture, I've sought to introduce students to a critical distinction in the law of criminal defenses. In the lectures that follow, we will spend some time discussing several specific defenses in the Code and in the common law. See you next time.